Good evening. Committee on State Affairs will come to order. The chair lays out as a matter of pending business House Bill 748, and the chair lays out as a matter of pending business Senate Bill 835. You'll recall both bills were laid out by Senator Paxton, and we had heard invited testimony. Both bills are now before the committee, and we will open public testimony on Senate Bill 835 and public testimony on House Bill 748. The chair calls Ashton Alarcon, Rob Collingsworth, Curtis Garrison, Katie Fruget, Christina Green. Yeah, there's Ashton. We're looking for Ashton Alarcon, Rob Collings. There he is, Rob Collingsworth, Curtis Garrison. Thank you, Dr. Katie Fruget, Christina Green. And the chair calls Cindy Castilla, Jennifer Allmon. Ms. Castilla was here. Oh, there's Jennifer, Ms. Allmon. And chair calls Dan Powers. Very well. And if I called your name and we don't have a seat for you, just hold tight and sit close by, and we'll get you on the next panel. Welcome to each of you. Ms. Allman, welcome. You know how to do this well, but I'm still going to remind you, when you're on the end, you got to get close to the microphone. Welcome. Introduce yourself. Give us your testimony.
Great. My name is Jennifer Allmon, and I'm the Executive Director of a Texas Catholic Conference of Bishops, and I'm testifying in support of House Bill 748 and Senate Bill 835. The Texas bishops are committed to using all efforts to end the evil of child sexual abuse. Over the past 2 decades, the reforms within the Catholic Church have significantly strengthened child protection. The Catholic Church's publication of the names of clergy and religious who have been credibly accused of sexual abuse of a minor is a public statement that abuse in the church occurred, and it is also a statement of a commitment to prevent such abuse. These publications and these bills respect victim privacy while still rejecting secrecy. Catholic dioceses do not enter into settlements which bind parties to confidentiality clauses related to the occurrence of the abuse, unless the victim or survivor requests confidentiality for specific details related to the settlement. For example, when a victim says, "I don't want my grandmother to know I sued the church," then we will allow that type of a provision to protect the fact that there was a settlement. But because we publish the names, we never agree to secrecy of the abuse occurrence. These bills respect that approach and allow those type of confidentiality clauses without the secrecy clauses. I know there's been discussion over the various versions, and we just want to reiterate that we believe that the House Bill 748, is the more comprehensive approach. So it is our preferred approach because it covers agreements with both children and adults, and we think there's value in that. However, the Senate bill we are still in support of because it is an incremental improvement over current law, which does not prohibit these agreements. And so both bills have our support, although the House bill is the more preferred comprehensive version.
Thank you, Ms. Allman. And let me ask you a couple of questions. And thank you for being here. And thank you for, I know you've worked with the authors on this bill and sponsor it. And thank you. And Senator Paxton asked a couple of questions of some of the witnesses this morning. Of course, this testimony is so important. I have a couple of practical procedural questions, if you don't mind, to give us a picture of how this works. And of course, I know you have a lot of education and training and experience, and you know, in lawsuits, and let me just zoom out, and we'll speak about lawsuits broadly. Not the subject matter here is just beyond heart-rending. But if we talk about lawsuits broadly, normally when a lawsuit is settled, whether it's a lawsuit or a claim that someone has for an injury or for a breach of contract, when there's a settlement entered into, it's customary in most litigation for there to be an agreement. I'm not going to file suit or I'll dismiss my suit. And confidentiality terms. Again, we're talking about lawsuits broadly, not these type of really, really exceptional cases. And so I think for many lawyers and for many people in the claims industry, it's just always assumed there will be a settlement agreement not to sue or to dismiss the suit and confidentiality. It's just assumed those go together. We've learned from some things that you've shared and from other witnesses that that's not necessarily the case. And so if you'll give us a little more detail about that. So in the claims that the church is settling, so how does that work as whether confidentiality is sometimes negotiated for, never negotiated for? Just help us understand what that looks like. If you don't mind, we recognize this is very sensitive. We want to make sure we understand the process.
Right. Well, I'm not directly involved in any of these suits or discussions,
right.
but I work with all of the dioceses and the diocesan attorneys. And my understanding of our approach as from our safe environment coordinators as well as our diocesan attorneys is we never discuss or bring up confidentiality clauses or agreements. We don't say, well, if you wanted a clause, we could put one in, wink, wink. Like we don't mention the words. But often, not often, actually it's very rare, because I ask some of our attorneys, could you give me an example of a time where we did a confidentiality clause? It was very difficult for them to find an example because it is so very rare. But in the times when it has occurred, it is typically our most traumatized victims that request it. They're never gonna come to this microphone and tell you about it in public.
Right.
They know we're going to publish the names. They know we will send a letter to the parish to say this particular clergy person has a credible allegation of abuse, and they don't want anyone to ever figure out they were the victim. And so they will say, please keep my name out of publication. Now, we never publish the victim's name, but if they are asking us to please sign to keep their name out, we will do that to honor their voice and their request as a survivor. And so there are times where there's a request to make sure their name is never affiliated or associated with our publication, our parish letters, our public announcements. And then again, the example I gave in testimony, situations of abuse occur within families, and it occurs within churches, it occurs within schools, because predators look for any opportunity. And that's why we have all these do not hire bills, and I'm so grateful that y'all passed one off the floor today to close these loopholes so predators don't look for these differences. But as long as they exist, predators are going to exploit them. And so you sometimes have family members that are destroyed by this abuse because, the father or the brother or the mother is still close to the abuser and doesn't believe their child. And so there's an inter-family fight, and the victim says, I don't want mom to know that I signed this settlement because she doesn't believe the abuse, and I don't want to get into that with her. Will you put this in? So it is the most traumatized victims who request a version of confidentiality, and our position is we will sign those types of confidentiality clauses as long as there is no secrecy clause. We will never sign saying that we cannot or they cannot disclose the abuser and the occurrence of the abuse. That is in the power of the survivor to choose whether they want to be associated with naming it. We will name the abuser because we made a public commitment in 2019 to always do that. And that is why on our website we have these publications. That in and of itself was a controversial decision at the time. At this point, many other faith denominations have followed that lead and are also publishing the names. And we think that's a part of the reform needed for pedophiles to understand they can't hide here. And this bill helps to deliver that message that we protect survivor privacy, but not secrecy for the abusers.
Thank you, Ms. Allman. That's a very relevant distinction. Perhaps we've used the term confidentiality or used other terms broadly, but I see what you're saying. If I got that right, there may be situations where the victim does not wish for their name to be released, but it sounds like in every case, the abuser, that there's never confidentiality there. Is that right?
That is correct. And that's why we appreciate the very careful wording of both bills to allow those provisions at the survivor's request for certain elements of privacy, but not for elements of secrecy. And the bills do a good job of that.
Thank you. Normally, we wait till our entire panel testifies, but while it was fresh, I wanted to make sure I understood that process that you've been through. Senator Paxton.
Thank you, Mr. Chairman. Those are really great questions, and thanks for answering those. So your confidentiality sounds to be exclusively focused on protecting the victim.
Correct.
You also described that it was that other denominations and religious organizations have started following suit, that it was controversial at the time. Mm-hmm. You created a real change in the culture around this issue.
We hope so, and we needed to do that as a part of our reparation for sins and crimes of the past.
Well, I think that's what we're really talking about at the center of these bills, is changing a culture. And I appreciate your language around, we're going to protect privacy, but we will not protect secrecy. And I especially love what you said, that you can't hide here. And I would hope that we as a state would take that position, meaning abusers, predators, perpetrators, that you can't hide here in Texas. Thank you.
Thank you.
And thank you, Senator Paxton. Senator Parker, you're recognized.
Thank you, Mr. Chairman. Jennifer, thank you very much for your testimony. And I know, as the chairman said, we're breaking out of our normal mode of hearing everybody first, but a lot to dive into here for a moment. So first of all, thank you for the church's leadership on this issue. And it's already been said by Senator Paxton and clarified by Senator Hughes. The focus, obviously, is not allowing these predatory monsters to hide with the structure that the church currently is employing. And I appreciate so much the bishops, the Catholic bishops in Texas, standing behind us in passing this legislation and getting Trey's law accomplished. I want to also, though, get your thoughts beyond passing this bill in terms of the culture that Senator Paxton talked about. And I really appreciate your commentary about other denominations now are following the Catholic Church in this regard. What can the Catholic bishops do further to lead on this issue and to continue to, really kind of be a guiding light for all the other denominations? I mean, because let's be candid, so many of the things that we've heard today and have known have been organizations that, at least in some form or fashion, refer to themselves as being a religious organization, a Christian denomination in some form or fashion, a Christian associated organization, but yet their conduct has been anything but. Mm-hmm. So I guess what can the Catholic bishops do to continue to lead and be an example so that not only do we get the legislation passed here, but that we really continue to change the culture in Texas and across the country? How do we do that?
I think there's a couple of things, and we've been very active and involved over the last 6 years in all the trash bills and trying to close these loopholes. And I think the discussion today on the Senate floor shows that Texas is leading, that the place where I think Texas is doing the best job is in trying to make sure that we are sending that clear message that you can't hide here. The interagency database that allows all state agencies that serve vulnerable populations to search the do not hire lists of all other agencies has been a critical piece. But frankly, what I would like to see most out of the current stage of the process is full funding for these child abuse prevention efforts the state is passing. So it's wonderful to pass a bill like Senate Bill 1849 from last session that does that interagency database, but if it's not fully funded in its implementation, I still can't search that database. So it's great to pass the bill. We have to fund the FTEs needed for implementation of the bills. So the bill you passed off the floor today was going to require significant funding in the conference committee for the FTEs to investigate those claims. Increasing transparency around reporting is really important. We're about to get an increase in reports because of the legislation this body has filed. But if we don't give SBEC, State Board of Educator Certification, the investigators to investigate those claims, children will be abused. Adults will report because they know they need to, and no one will be there to investigate so that predator can continue to abuse. So to me, the biggest gap is the funding. And so I think in terms of a proactive approach, that's something we can lead on and call for the state to give that funding. I think in other ways, the Catholic Church is uniquely positioned because of our hierarchical structure. Today's a good day to talk about the hierarchy with the
Absolutely.
selection of a new pope. And that's not to say, what that means though is that the bishop and the pope can issue a decree and the church will do it. Other denominations do not have that structure, and so we can't fault them for being unable to make the level of systemic changes the Catholic Church can make because they have independent churches and they have autonomous pastors. And so there are a tremendous number of Baptist pastors, Lutheran pastors, Methodist pastors, who are doing really good work in this area. But it only takes one to have a problem for a super predator to thrive. Because they don't have the hierarchical structure to say all Baptist churches are going to do this now. That's just not how their theology works. So our theology put us in a position to lead because the bishops in 2002 in Dallas signed the charter that all dioceses will do this, period, across the board, in unity. We have the structure that allows that. So I want to make sure that as I talk about the work we've done, that I know that other denominations and groups are doing tremendous work as well. But just like there are loopholes in the state system, there can be loopholes in the church. And there was a bill passed a few sessions ago in the House, well, it passed both chambers. That's a really important legislation I don't think people always recognize that prevents liability lawsuits against churches who disclose abuse. And I think a lot of churches are not aware of that law. So better promulgation of that law was a bill by Scott Sanford back in 2019.
A pastor himself.
A pastor himself who, because of abuse he saw within Baptist churches, as a Baptist pastor, he was unable to report to other Baptist churches that there was a predator because he could be sued. And so it put a gap there. So y'all passed a bill that said you cannot be sued as a church, as a religious organization, as a private school for telling of abuse. If you have a credible allegation, a reasonable cause to believe, and you warn another employer that someone was dismissed from your employment, investigated, had a credible allegation, you cannot be sued for defamation. And that's really important. I think Texas has done a lot of reforms that people are not aware of that give churches tools to do better, and I think some better public education about those efforts would really help.
Oh, very good. Thank you. And your comments about the financial piece, good things that we've passed historically not being funded, I think is a very important takeaway for us to share with our colleagues, particularly as we're in conference here these final 10 days or so here at the budget. So thank you for sharing that, and we'll connect the dots. It's really enlightening and good feedback. One more topic broadly. If you wouldn't mind, when you have a situation with a predator and that needs to be addressed, obviously you talked about how their name is disclosed, all those things appropriately, which is great to bring sunlight to this darkness. What are the sequence, if you will, of events? Take us to the process when there's a concern about a predator, once it's been convicted, whatever, what are the processes when they're removed? And then at what point, do you turn them over to the authorities? Can you just kind of speak to that? Just kind of give us a high level of what that looks like within the Catholic Church today.
Sure. So when an allegation is made, every Catholic diocese has a victims assistance coordinator and a safe environment coordinator. It's often the same person. In larger dioceses, there might be two. And so an outcry is made. If it is made to a teacher in a private school or to an employee of a church, of a parish, then the person who receives that allegation first, all of our direction and policy is to report first to DFPS and law enforcement consistent with Chapter 261 of the Family Code within 48 hours. And so that report is made to those two locations. But we don't stop there because, unfortunately, oftentimes the follow-up doesn't happen, which is what I talked about in terms of the full funding.
Yes.
I'm not criticizing the investigators to say that the follow-up doesn't happen because they don't care. They don't have enough staff, they don't have enough personnel, and they can't do the investigation. So when we monitor and watch, if we don't get a follow-up phone call for further questions within 48 hours of our report, or within a set amount of time, I can't be certain on the time, but if we don't get a follow-up, we call back and say, no one has come out to the school to investigate, and we reported this, and no one has been here. And then they might—
So it's a lack of staffing, so to speak.
Lack of staffing. So
Wow.
law enforcement might say DFPS has to do their part first. They haven't done their part. We can't do our part. We'll call DFPS back and say, you need to get an investigator out there. We believe this allegation. We've removed this person from employment. We've removed them from contact with children, but they are in the community and they should not be. And we follow up and push, and we have had to do that in Texas more than once. And eventually, they do have the staff and come in and do the investigation and proceed. But we don't wait for conviction to remove. We remove at outcry. And so when the outcry occurs, the reporting occurs, the removal occurs, and then every diocese has a review board. The review board consists of social workers, psychologists, law enforcement, FBI, parents, a variety of well-trained people who know how to look at these cases. They review the allegation to make a recommendation to the bishop on the credibility of the allegation. And then the bishop, once that review board meets and presents that credibility, that's when their name is added to the list. Because we are not doing our own investigation. We are not law enforcement. We are not DFPS. That is the role of the state.
You turn it over.
Always be.
Yeah.
We turn it over to the state. And we're very clear, no one should be reporting to the diocese an allegation if it has not been reported to the state first.
Yes.
Second, they need to tell us so we can remove them. So we're very clear in our training, and that training begins in 6th grade. We have safe environment programming for kids in our schools that are younger than 6th grade, but we don't talk as explicitly. We have anti-grooming training, but we are telling our kids starting in middle school, if someone has done something inappropriate, you tell. You tell us, you tell your parents, you can tell any adult at this school. And so that creates an environment of telling instead of an environment of secrecy. And so really, that's the beginning. I started at the point that the outcry gets up to the diocese, but really the beginning of our process is telling children to tell. And that starts in elementary school in terms of, feeling weird, but with more explicit detail in middle school.
Excellent. And my final question is, I guess, a simple one, but how do the Catholic Conference of Bishops feel about the first American Pope here this afternoon? What are they thinking?
We are thrilled with all popes at all times as good Catholics, but especially excited to have one of our own, and especially excited to have a Pope Leo XIV. I think the bishops are looking forward to what this new Pope will bring to our community.
And his leadership on this issue.
And his leadership on this issue, absolutely.
Thank you very much.
Certainly.
Thank you, Senator Parker. Senator Betancourt, Senator Birdwell, I did that for your benefit, Senator Birdwell. You gave me that look. Yeah, go ahead.
So let me ask if I may. I need to broach the other end of this spectrum that's just as difficult to deal with, because we've seen the things that you've described and the manner in which you testified earlier about, secrecy versus confidentiality. How does the NDA, one of the Lord's 10 commandments that's he said there's a lot of important things, but here's the 10. And one of those is bearing false witness. Mm-hmm. How does both bills, affect the conduct of somebody that is falsely accused? And in entering an NDA, is that considered an admission of guilt? Because it's better to enter into the NDA than to go to court.
Mm-hmm. The way we approach that issue is that if a person has made an outcry and come to us, we consider that our responsibility of the church is to meet them where they are pastorally. Even if it's a false allegation, we listen, and if we don't believe them, we still provide them the pastoral support, counseling, and assistance needed for their situation. That allegation, if we do not deem it to be a credible allegation, would not result in a person being listed on our version of the Do Not Hire list, our clergy publication. And so that's the reason we do that National Review Board. I call it National Review Board because there's a national version as well, but the Diocesan Review Board is really the proper term in Texas. So the Diocesan Review Board is making sure this is not a false allegation. It's a credible allegation.
Is the NDA assumed to be a necessary tool because there's not enough evidence to pursue criminality? So this is always, I know obviously it's civil, but if somebody if you believe you have enough evidence that it's not just credible, but there is enough evidence to pursue criminality, is an NDA applicable in any way for something that would be criminal as opposed to civil?
I'm not sure I fully understand your question, but let me back up and try to respond, and then you can help guide me if I'm.
Well, because what I'm really driving to is I don't want the NDA, I don't want the NDA to drive our jurisprudence from innocent till proven guilty to guilty till you prove your innocence.
Got it. Well, as I've said, we don't use NDAs, and that's why we support this bill, because we don't believe the NDA is a tool to healing and restoration. And we take a restorative approach to all of these conversations, and we believe in restorative justice for both the victim and the accused.
Scripture was very
And that's
clear
really
about
the heart of what the
restitution,
point
so
is,
restorative,
right?
yeah,
Is
yeah.
We, so the decision of the church to provide therapy and counseling and financial assistance to a person who's come to us with an outcry is not necessarily saying we think this happened a specific way necessarily, but it's saying for this survivor, they are seeking this assistance from their church, and we want to walk with them and provide it. The question of criminality is a state question, and we have reported them. So the minute well, I can't say the minute, that's probably hyperbolic, but within that appropriate time period, within that 48 hours, we're making those reports, and we believe it is inappropriate for the church to determine criminality.
Well, I'm not asking you to determine criminality, because there's a separation of function. That's
Right,
why
right.
God, the Lord gives Moses
Correct.
administration, and he gives Aaron responsibility for the church. So there's a separation of function.
Right.
I'm supportive of where we're trying to go here. I'm just trying to make sure that that we don't end up inversing guilty till you prove your innocence, as opposed to innocent till proven guilty, even though that's a criminal standard as opposed to a civil standard. Civil standard's preponderance of the evidence. So I'm just, in listening to your discussion and how you're handling that, I'm just trying to make sure that even if it's a civil accusation, that it's
Properly vetted
innocent
and not
till-
just assumed guilty.
Yes,
And that's
ma'am.
why we
That's
have
what
the
I'm-
review board.
Yeah.
That's the purpose of the review board, is to take that, and the review board consists of experts who have the ability to make those judgments. That isn't the gift of the church to make those judgments. That's the gift of professionals, social workers, psychologists, law enforcement, FBI. They're the ones who evaluate the credibility of the claim and make a recommendation to us on their view. And we trust those recommendations because we value and trust their expertise.
Yeah.
And so in canon law, in the Catholic Church, we use canon law as our legislative guidelines. And in canon law, there's a provision about making sure that the bishop is always protecting the good name of a priest. And so when we made the decision on publication, that was a conversation, is that we are publishing the names of deceased individuals who cannot tell us, I didn't do that. And we're having to make the decision of, do we put this name on this list? And in our ecclesiastical approach to this, our theological approach to this, based on the body of evidence that we had, we believed the allegation, and we believed that the transparency for the survivors and the listing of the names so that survivors who had not yet come forward would do so knowing they would be believed was of value. And there were lawsuits against the church for the publication of names by people who believed their names didn't belong on that list. We won all of those lawsuits because of the ecclesiastical abstention doctrine, that the church could make that determination theologically to place those names there.
Right. Recognizing that you're speaking as a faith-based, religious-based organization, how do you think this would change for based on what you just said, a non-religious organization?
In terms of this bill,
Yeah.
I think this is a good bill for religious and non-religious organizations because it upholds the value of privacy and ends the value of secrecy that too many people, the misvalue of secrecy that too many people have had. And I think it's important that we take this step, and I think the families that have brought this bill forward have done so with the greatest of intention, and the content of the bill reflects the careful study And we hope that it passes, and we're able to. We know from our experience, there's institutions who might be fearful of a bill like this, and our point is we know from our experience that this bill helps to restore victims. It brings about restorative justice and healing. It encourages talking and therapy and survivors getting back their voice, and that can't be bad for any institution.
Yeah, that's true. Thank you. Mr. Chairman, I do have another question, and since I missed this morning, what I'd like to do, I don't have questions for the panel, but I do have a question for Senator Paxton that I think you would be helpful as an attorney in helping answer the question, but I will defer it till this panel's done testifying, if I may do so.
Senator, that's fine with me. We'll be here, and so if you want to wait till after the witnesses, we can have that dialogue then. That's fine. So you'd prefer to wait, or do you care? It's up to you.
Okay. Well, I was just trying to be courteous to the other four.
We can wait till after the witnesses. That's fine.
I'll do that. So,
Thank you, Senator Betancourt.
Thank you, Mr. Chairman. Jennifer, you've testified for both bills at this point. And the use of non-disclosure agreements has not been something the Catholic Church ever condoned, or at least in the Americas.
It has been the policy of the Catholic Church not to use non-disclosure agreements since the Dallas Charter in 2002. There may have been some non-disclosure agreements prior to 2002. We do not enforce those agreements since the Charter in 2002 when we banned their use.
Right. So, and that was an administrative decision following up on the comment, not a canon law decision.
Right. That was an and actually, it isn't. It is a decision the bishops chose to bind themselves to collectively, which is not traditionally how the Catholic Church operates. We have a pope, and not just today.
By habemus papam,
Right.
I believe. My Latin's a little rusty, but we have a pope.
We have a pope, and each bishop reports directly to that pope and not to each other.
Right.
And so each bishop can decide how they're going to handle these types of policies. But the bishops of the United States, beginning in 1986, began reform in this area, understanding that their previous approach was not as informed as they were becoming in the 80s and 90s as the standard of practice on these cases changed. The bishops learned more. They started a reform process that was concluded in Dallas, Texas, nationally, and the bishops collectively, as a body, signed an agreement to hold one another accountable for compliance with the Dallas Charter. And so in that way, instead of it being up to each of the 16 dioceses of Texas to develop a policy,
Or the other dioceses.
or the other dioceses of the United States, the dioceses of the United States have adopted this policy, and we have an outside accountability review by the John Jay College every year on how we're doing in complying with our policy, with our reporting, with our processes. And that's a very unusual step for the church to take, but it shows how important it was that we got the reform right.
It was a necessary step, especially at the
Necessary
time.
step.
Now, and during that process, was there ever any discussion of age on non-disclosure agreements? I'm just curious because that seems to be the major difference
In the
at this
two
point in
bills.
time of the two bills.
I don't know because I wasn't here during that time. I can tell you that our diocese today do not use non-disclosure agreements which bind parties on confidentiality of the abuser and occurrence
any
for
age.
any age.
Okay.
And that's why we can support both versions. And because our policy is that we don't do it on any age, we think that is appropriate for state law as well, and why we prefer the more comprehensive all-age approach.
Okay. Thank you so much.
And thank you, Senator Betancourt. And welcome. Introduce yourself and give us your testimony.
Hi there, I'm Christina Green. I'm the Chief Advancement and External Relations Officer for the Children's Advocacy Centers of Texas, or CAC Texas, and I'm testifying in support of both House Bill 748 and Senate Bill 835. And CAC Texas represents the 70 Children's Advocacy Centers, or CACs, across the state. You all have them in your district, and we collectively serve over 60,000 new child victims of crime every year. The majority of those are survivors of child sexual abuse. And we coordinate and facilitate the joint investigation, both on the civil and criminal sides in these cases. And very grateful for the stories of the survivors that you heard from this morning and that you will hear from later on this panel. And want to emphasize that while their stories are difficult and hard to listen to, they are not unique. And we have so many children walking through the doors of our children's advocacy centers every year and every day, quite frankly, across the state that share similar stories, that have the similar threads of secrecy and grooming and people that they love and trust that have violated that love and trust. And those are just the cases that both a child outcries and then they're reported to law enforcement or DFPS. We know in Texas that 1 in 6 children will be impacted by child sexual abuse before their 18th birthday. With over 7 million children in the state of Texas, that is a colossal number of children that are impacted. And if we are working as a state to support these children and make sure they have a chance at healing and thriving, and also maintaining public safety in our communities, we need to make sure that we are creating an environment in which there is no secrecy in these cases, and that we are equipping our law enforcement and prosecution partners to fully investigate these cases to the fullest extent of the law, so that we can remove these perpetrators from our communities, from our institutions and our schools, to make sure that we're preventing future abuse from happening, because we also know that these perpetrators will perpetrate on the same children multiple times and other children until they are caught and held accountable. And so this bill is incredibly important, and that we're bringing this issue further out of the shadows. Elizabeth this morning spoke to the fact that creating an environment where we know that survivors will be believed and listened to is paramount. And also, in order for your investment in children's advocacy centers to make the change that it's supposed to get at the truth, Senator Birdwell, of what has or has not happened, because our model was actually founded in a lot of cases where there were false allegations. And we needed to make sure that we were talking to children in a neutral, fact-finding, evidence-based manner. But in order for them to tell their stories, we need people to feel comfortable coming forward, and NDAs prohibit that as a culture, as a society. And so we need to continue to bring this issue out of the shadows and into the light, and continue having conversations about it and supporting our victims. And then also being there for the healing process. At CACs, you all as a state fund our mental health services, and we serve those children throughout the duration of their cases and even into adulthood should they need our services. And oftentimes we're serving the caregivers. I can't tell you how many times that I will speak at a hearing or somewhere else, and I have adults that come up to me and say, I've never told anyone this, but I'm a survivor. And that emphasizes the beauty of the House version of this bill, because it does not have an age limitation. And we know that there are a lot of adults that do not outcry of child sexual abuse until they are well into adulthood as well. Thank you for your support, and thank you so much for prioritizing this issue and supporting child survivors of sexual abuse.
Thank you for your testimony. Senator Parker, you're recognized.
Thank you, Mr. Chairman. Well, thank you for your testimony, and thank you for all the great work that CACs do. And I've been blessed over the years to work with the organization, and I think the world of what it does. I'd like to ask just a question about frequency. Appreciate your moral clarity, just like I'm so grateful for the Catholic Church having such moral clarity on this issue today and being supportive. How frequently, when you're seeing some of these horrific cases of these precious kids that have been abused, clearly, it's gone beyond the doubt that it occurred, very clearly documented and so forth. How frequently are you seeing over the course of the last decade across the state, all your different tentacles of the CACs, how often are you seeing these kinds of disgusting NDAs being utilized to get involved in really protecting predators, is how I view it. Can you speak to that for a moment from your perspective?
Great question, Senator Parker, and the answer is we don't know because they can't talk about them. In our cases, generally there's going to be a criminal offense and criminal component. So there is a criminal trial and investigation in which they are cooperating with law enforcement. And that's, we want those families and children to be engaged in the investigatory process, because then we have the information to move that case forward. However, if there's a civil NDA, we would not be aware of it because they can't speak to it.
Boy, isn't that sad? But yeah, and it's prolific, unfortunately, but obviously they're effective.
Yes.
Sadly. Okay. Thank you very much.
Thank you.
Thank you for your testimony. Welcome. Introduce yourself and give us your testimony.
Thank you. Sorry, that was a little quick.
You take your time. That's fine.
Thank you very much. I appreciate it very, very much. I'm Curtis Garrison, and I support HB 748, SB 8035, aka Trey's Law. I was sexually abused as a child hundreds of times, starting when I was a toddler. I have zero tolerance for any kind of sexual abuse. NDAs and statute of limitations are not zero tolerance. If you want to protect children, you can't protect predators. I was first sexually abused by my adopted dad, Flynn H. Garrison, who was sexually abusing my adopted sisters, and adopted brother. We all moved out before we were 15 and 16 years old. And then there's more foster kids than this that were sexually abused, and of course, that's me in the center. I'm also one of the 82,209 Boy Scouts. Here I am in my troop. 82,209 Boy Scouts bankruptcy claimants. And I was sexually abused by my church's scoutmaster when I was 12 to 15 years old. My perpetrator was a known perpetrator, but the BSA did not tell anyone. He was known before my troop, and then he was arrested twice after he left. I aged out and moved on. The BSA has NDAs with hundreds of claimants that settled out of court. They have NDAs with their employees, or they will lose their pension and benefits. There are over 82,000 claimants because the BSA did not report predators for over 100 years. Claimants are dying every month at the rate of around 100 a month, waiting for justice. In Texas alone, there are 5,369 claimants in the BSA bankruptcy. The BSA was told about a perpetrator on average every other day, and they hit them, several thousands, and they are still hiding the perpetrators, thousands of them, despite the bankruptcy, which was filed 5 years ago, February 18th, 2020, and we're still fighting them for justice. Sorry. In 2010,
You take your time. That's fine.
I clear my throat.
That's fine. You take your time. You're fine.
In 2010, Gary Lewis, a survivor of 17 BSA survivors sexually abused in his troop, he didn't sign an NDA, and instead the BSA unusually went to trial. I'm trying to catch my breath, sorry. Thank you. The BSA lost severely, and thousands of their perpetrators were publicly released as a part of their court process. And for the first time ever, they were released publicly, and one of them was my perpetrator. And as soon as I found that out, this was 2010, I was a Boy Scout in 2012. 1982. I felt vindicated, and this helped me be one of the survivors that made the BSA bankruptcy happen. Where is Roger Crone and Glenn Pounder from the BSA? Where is Joe White after the Kanakuk tried to justify their use of NDAs? They should be here if they really cared about children. They should rescind NDAs and help eliminate statute of limitations. I've been fighting for justice my entire life. Too many institutions that portray to help children hide and protect predators that harm them. And countless people that are being harmed after the fact could have been prevented. It's such an easy thing to prevent if you just hold these people accountable. I have PTSD, and I often wonder if survivors, if we were physically injured where people could see the harm and the injuries, maybe people would understand how it affects us for life. I'll just share that I've been up for 2 days, and it's just my schedule. It's kind of normal, but this is a long day for everybody, but I can't sleep normally. You wake up in the middle of the night, like pounding a pillow like your house is on fire, and you don't even know why you are having that issue. It's hard on relationships and keeping a job. So Texas needs to pass Trey's law now and protect children, not predators. Thank you.
Thank you. Awesome.
Mr. Garrison, thank you. Thank you for your testimony. Thank you for being here. Mr. Alarcon, you and I met briefly this morning, And so when you're ready, introduce yourself and give us your testimony.
Good evening, Mr. Chairman. Thank you, and good evening, members. My name is Ashton Alarcon, and I am a captain of our United States Air Force, where my wife and I serve in Misawa, Japan. I was fortunate enough to fly in for this hearing today, so thank you. I'm one of the victims in the Kennecott case with Joe White and with Kennecott and Pete Newman. And I'm one of the victims that did not sign an NDA. As you heard earlier this morning, my father expressed my desire as a young 14-year-old man that I wanted to tell my story. I can't explain it at the time, but I knew the impact that it would have, that there would be some good to come out of this if I was able to keep my voice. I wasn't able to keep my purity, I wasn't able to keep my sanity at the time, but I was able to keep my voice. So I'm in strong favor for HB 748 Trey's Law to move forward. I'm here to encourage each of you senators to make a legacy decision. To start with the words of our founding father, Thomas Jefferson, that Elizabeth Carlock spoke earlier, it is not so much a law-abiding phrase, such as our Constitution, but it is nonetheless a moral compass that frames the expectation that government should protect individual freedoms and human dignity. And that, as you know, is the right to life, liberty, and pursuit of happiness. So I was pondering this. I asked myself this question: why, if this is what our nation was built on and believes in, why is there a tool like NDAs for abusers to use that does the complete opposite? Today you have the power to vote in favor of a bill that upholds what this country was built on. There's 6 reasons, 6 main points I want to express that the ability to have my story has done for me. One is emotional processing. Sharing enables the brain to organize fragmented traumatic memories. And telling my story has helped me connect emotional fragments of my experience, resulting in less intrusive thoughts and flashbacks. Number 2, feeling seen, heard, and validated. Sharing my story has helped me rebuild trust in relationships and my self-worth. Number 3, reducing shame and self-stigmas. Speaking openly has enabled me to counter the internalized belief that my trauma defines who I am and that I am, quote unquote, less than. Being vulnerable, especially when met with empathy, has helped me dismantle toxic self-beliefs. Shame thrives in secrecy. Sharing breaks the silence, dissolves the lie that I am alone, and transforms pain into power. Although names like victim and survivor that I did use at my opening statement in situations like this are used to identify me in settings, they imply a negative. However, telling my story has given me time to reclaim my identity, especially my identity in Christ, and I am a conqueror, not a survivor. Number 4, gaining perspective and meaning. Articulating my story helps me make sense of my experience, and each time I share what happened and how I am changed, healing, and growing, and how I manage helps me find purpose in my suffering. The abuse I suffered is branded into my life story. Sharing that part of my life is a core part of post-traumatic growth, where I can find insight, strength, and compassion. Number 5, empowerment and reclaiming agency. Sharing my story gives me the narrative power, that I decide how my story is told, rather than being silenced by what has happened to me and the perpetrators who want to pretend like they are without fault. Trauma often involves a loss of control. and telling my story is an act of regaining ownership over my life. Lastly, communication and connection. Sharing my story has been one of the greatest buffers against trauma's long-term effects. We all have a biological need for belonging and safety. Trey's law protects that need and creates a life where that is possible. I briefly want to share one example where I saw this come to life when I was on a mission trip to Hungary at the age of 19. After I graduated high school, I went on a mission trip with my mother, who's here right now. Although I fought for my right to tell my story, it's not a fun story to tell, and it's certainly not fun to listen to, even have others share theirs as well. When I was on a mission trip in Hungary, on the last day, I felt the Holy Spirit ask me to share my story. I told him no, that I was upset with him, and that if he wanted me to tell my story, someone was going to have to come and ask me. As we were leaving on the last day, or prior to the last day, a member of the mission trip came up to me out of the blue and said, "Hey, we need a person to tell their story. Something happened. Would you like to share your testimony?" I immediately knew then that I was going to share my story, and before I could say no, I said yes. Little did I know the impact that would have the next day. I stayed up all night thinking, how am I going to translate this into another language? The pastor also stayed up all night and couldn't sleep, of that church that we were with. When I showed him my story, what I had written, he told me this is the exact message that we had been praying for, that there had been generations of sexual abuse within Hungary, generations. So when I got up and told my story, he said that never has his church been filled with people asking for healing, speaking out, that had never shared with anybody, that they had not seen anybody who has come forward about this, has healed from abuse like this, and to speak with such power and authority was so foreign to them. But I did not do this alone. This is a life journey. This is something that I need to share with others, and others need to know that they're not alone. And that confidence is gained over time. Voting against Trey's law will have psychological, emotional, and ethical damage to our country, mainly for 5 reasons. It suppresses emotional healing. It reinforces shame and isolation. It blocks connection and support. It undermines autonomy and enables perpetrators and systems to avoid accountability. Long ago, there was a nation that cried out with this lament that now echoes one in my own heart. Must I forever see these evil deeds? Why must I watch all this misery? Wherever I look, I see destruction and violence. I'm surrounded by people who love to argue and fight. The law has become paralyzed and there is no justice in the courts. The wicked far outnumber the righteous, so that justice has become perverted. Those testifying today and in favor of Trey's law are ready for justice for the oppressed. Remember, senators, the tongue has the power of life and death, and those who love it will eat its fruit. May you be moved to better America, and may the outcome of today protect our children, men, women, boys, and girls forever, so that their voice may bring life. As I fight to protect our freedom, please fight for my voice and the voice of others like me. I'm happy to take any questions. Thank you.
Thank you for your testimony. Thank you for sharing that. And we may have questions as we go, so y'all stick around, please. Thank you. Welcome. Since you're on the end, you got to get close to that microphone.
All right. I can do
Introduce
that.
yourself and give us your testimony.
Well, first, thanks for the opportunity to speak in favor of HB 748 and SB 835. My name is Dan Powers. I'm a mental health professional. I'm a clinical social worker, and I've been working with kids who've experienced abuse for the past 37 years. And I thank these two guys for reminding me why I do what I do. And I sometimes you got to get that back. For the past 25 years, I've worked at the Children's Advocacy Center of Collin County. I've overseen our clinical programs. I'm privileged to help kids heal, where children can receive services for the rest of their life. I'm honored that our CAC is in Senator Paxton's district. I'm also honored to live in Carrollton, in Senator Parker's district. Sexual abuse is about power and control. The secrecy and coercion to keep the secret allows sex offenders to continue to victimize children. And you've heard today, long after the actual physical act of abuse. I've worked with hundreds of children that have experienced abuse and been involved in the criminal and civil court systems, a place where kids shouldn't be. These kids I work with, I tell them, sometimes adults get it wrong. But today, you've got the power. It's no longer a secret. You let everybody know what happened. You let everybody know you're no longer afraid. I remember a 12-year-old girl on the witness stand. At the end of her testimony, she pointed at her abuser and said, "You took my voice, but now I've got it back." Children are unable to fully heal until they get their voices back. Non-disclosure agreements reinforce the offender's power, silence the brave, and continue to put children at risk in our community. I urge for the passage of HB 748 and SB 835. Thank you.
Thank you for your testimony. Senator Paxton, you have the panel.
Thank you, Mr. Chairman. Thank you all for being here. Curtis, you did great. Ashton, you did great. Thank you. So I've met Curtis before, and I've heard his story. And it takes a tremendous amount of energy and courage to tell it. Thank you, though. Ashton, captain in the U.S. Air Force. I shared with Ashton earlier, my daughter was a captain in the U.S. Air Force when she severed, and thank you for your service. So I just want everyone to know that God is at work. You listen to Ashton's story, and you know, Ashton, so many people who go through these things, especially when it has an aspect of spiritual abuse, which yours did, it so distorts their view of God. And one of the most beautiful things I see in your testimony is your healthy view of God. And I'm so thankful for that. God has done that, but you've been very brave to pursue the healing. Ashton is here in Austin today because he was already coming to his brother's graduation at UT. He came from Japan, but it just so happens that this hearing is today. And so I think God worked really hard to get you here so we could hear your story. Thank you.
Thank you, ma'am.
Christina and Dan, thank you. So Dan, you have worked with children,
Yes.
and you have also worked with sex offenders.
I'm also a licensed sex offender treatment provider. I've worked with adolescent offenders. I've chosen in my career not to work with adult offenders.
You mentioned that NDAs promote secrecy and coercion.
Yes.
Why do you use the word coercion? I think we understand the secrecy, but why do you use the word coercion?
Because it's another form of power, and it's coercive. It's scary. I've heard actually just today being afraid to tell my story, even to my therapist, because that cloud, that monster is still there, and that's really what it is. It's a monster that's still there and still controlling a child's life long into adulthood.
Have you ever seen an NDA that in a victim's life that served them well?
No, I have not. Prior to being at the Children's Advocacy Center, I had a counseling practice for 10 years, and I worked with kids that were involved in the Boy Scouts, were involved with the Catholic Church, and no, I've never seen that be a benefit. I understand the point that was made is that sometimes they for themselves, but that's not what we're talking about today.
That's confidentiality,
yeah,
right?
we're talking about the perpetrator, the organization that allowed that perpetrator to do what they did to have control, not the child, not the adult.
One of the things that we heard in some of the testimony this morning, and I think with Curtis and Ashton as well, is that that the NDA also creates isolation for the victim. Could you talk a little bit about that, and why would that be important to someone that's initiating the NDA?
Well, I think, again, it goes back to control, but I think for that child, the abuse is always going to be part of their life. It's part of who they are. And it doesn't have to control their life, but it's going to be who they are. And to ask a child, ask an adult to say, you know what, just take that part and put it aside and don't talk about it, continues the shame, continues the, it's very common for kids especially to feel like the abuse was their fault. And I think this reinforces that. You can't talk about it. And it's continuing that victimization.
When you work with children who have been abused and have made an outcry, or in your private practice as well, just any victims that have dealt with this, how common is it for a perpetrator to tell their victim, you can't tell anyone?
Oh, absolutely. For a sex offender to commit what they do and continue to do it, they've got to keep that child silent. They may say it verbally, they may imply it, they may do it with force, they may do it with a gun. There's a lot of ways that they tell a child to be quiet. But if a child speaks, the sex offender is going to be held responsible. They're going to go to jail. Here in Texas, they're going to go to prison for a long time. They know that. So it is very important during their grooming process to identify a child that they can silence. That they work hard. They do it through threats. They do it through coercion. They sometimes do it through favors, making a child feel extra special. And that relationship will stop if you tell the story. They're amazingly skilled at manipulating a child and manipulating everyone around that child to get what they want.
Can you think of a good reason for a person to tell a child, you can never tell?
There is no reason. And I raised 2 sons, and we always talked about there are no secrets here. There's surprises, but we're not going to have a secret. And if there's ever something you can't tell me, we identified other people in their life that they could tell something to, so that would get out, and they wouldn't have to hold that secret.
Jennifer, you testified that when the church made this change in the culture, how this was treated when it was discovered or alleged, that it was a difficult process, but that you feel that now that it is better for children or anyone who has been abused in this way, and also for the perpetrator. Would you say this is also their path to something better, being caught in a certain sense, as opposed to continuing what they're doing?
Obviously, yes, it's better for them to be caught so that they can stop abusing. And we hope that they stop abusing because they've gotten the therapy and treatment needed, but we know that's rare, that can be effective with adult abusers especially. And the primary reason that they will stop is that they will go to jail, is that the Texas will proceed with the appropriate criminal justice response to this and protect people from these types of predators. And so, yes, I mean, I think in terms of the impact that you see of the reform within the church, I think just the publication of the name shows the impact of our reform, because if you look at the chart at the level of abuse in the 60s, 70s, 80s, 90s, and then the number of names that are on that list for abuse that occurred after the Dallas Charter was signed is significantly less. It's something like, 18 names after the charter was signed, and 200-something before. And that, our publication goes from 1950, I believe. I think one diocese went 1940 because their diocese was established in 1940 and they wanted to go back to the very beginning. It was a 70-year publication, and there were a number of victims who came forward because their perpetrator was on the list. And, you know, we think it produced a great value for change.
And the church overall is in a better place.
Absolutely.
I believe Ashton's father this morning testified that that Kanakuk's approach was, we're going to reform this guy. And so they did not hold him accountable, but gave the indication that they were going to do the work to help him get better. And I wonder if in your work, Dan, if you could kind of speak to how that typically goes.
Well, the bottom line, an offender has to get caught to get treatment. I mean, you're right on. And we don't have a bunch of sex offenders saying, hey, can I get treatment, please? You know, holding up their hand, because there's, you know, obviously some big consequences for them. But getting the secret out does a couple things for the offender. One is it allows them to get treatment, and they often don't want it at first for obvious reasons. But allowing the secret to continue is not beneficial for a sex offender's treatment either. It allows that secret to stay, and what we call a cognitive distortion, that it was okay. And what a cognitive distortion is they're just creating their own reality. And what I feel a non-disclosure agreement allows that offender to do is just reinforces that disclosure that they're really not at fault. Because if they were at fault, everybody would talk about it and we'd make it public. It's secret, so I can keep that secret. So I believe it would reinforce that, which makes them more dangerous in society.
It was reported that by one of the prosecuting attorneys in the Kanakuk case, I believe, that they believe there were hundreds of victims. And these victims didn't really know about each other, which is another part of the secrecy, right? And an NDA, keeping that secret keeps the big secret better when victims don't know about each other. It did not help the perpetrator at Kanakuk, and it doesn't typically help. What does help is holding people accountable by breaking the silence about what's going on. Thank you. Thank you all for being here, and I appreciate your testimony.
Thank you, Senator Paxton. Senator Parker, you're recognized.
Thank you, Mr. Chairman. Well, first of all, I wanted Curtis and Ashton to know that you guys are incredible role models and how proud we are, all of us here in Texas Government R of you and coming forward. Because the only way you break this cycle of darkness in our country and around the world is to come forward. And I also believe this is, of course, Dan's area of expertise, that when you're able to talk about it and articulate it to people that care and that have your back, that I think there's something therapeutic in that. And I think that's clearly clinically proven, Dan, is it?
Absolutely.
And so just want you to know how proud we are of both of you and what you've done, and all the victims that have ever occurred in this state. We're deeply sorry, and we want to do everything in our power to move this forward in a positive way to bring restorative justice. And just can't thank you enough for your role model, being role models and your leadership, and you're really heroes in society, because until we break the cycle and people talk about what happened, it will continue to grow and fester in the darkness, outside and above and beyond the issues of the NDA. How do we get to the core root of this sickness? It's only because we come forward and talk about it and really shine the spotlight that will turn the corner. And I think, Dan, from your perspective, obviously as a mental health professional, you know, obviously there's this huge therapeutic value associated with talking. And, you know, the anguish, I can't imagine the anguish that you all both have gone through, and along with so many others that, particularly those that were locked under one of these NDAs, that they had no ability to express their emotions. And to think about that happening in Trey's case to a young child and what that does to you psychologically is just devastating.
Yes.
If you have a cast on your arm or your leg, people have sympathy and know what's going on. But when you're dealing with something that deals with the deepest levels of your soul and how you've been hurt so badly by those, sometimes, some cases, a family member that you loved and trusted and so forth, along with all the other complexities, it just is even more damaging. So I guess, Dan, my question to you is, what more can we do to address, one, the exposure of this, but two, the healing? What can Texas do beyond all the legislation that we've carried over the years, all the bills that we've done, better funding that Jennifer talked about? What better we can do from your mental health professional perspective?
Absolutely. And Senator, I'll just reiterate, when I talk about abuse, it affects a child's soul. It's not a physical act. It's an emotional, it affects a child's soul.
Yes.
And internalizing it is part of that process of fear. And what the perpetrator has done is you got to keep it inside because you're afraid to get it out because they've created an environment of shame.
The predator programmed that.
Absolutely. So an important part, what you're talking about is externalizing, exactly what these guys are, that's a term we use, is getting it out. And it allows the people who love you the most to protect you, to help you heal, to hold you up. And that's, it's huge. Your question is, what can Texas do? Support mental health programs for kids, especially kids who've been abused. You've done a wonderful job in doing that through children's advocacy centers. Unfortunately, I have job security for the rest of my career. We have, as Christina said earlier, we have 1 out of 6 kids, and we're seeing those kids, and those kids need our help. And we need to have as much power to protect these kids and to help them heal than that perpetrator had, and to overpower that. And that's how the state can support our children, by supporting the professionals who do amazing work every day.
Very good. Well, and certainly know the great work of the CAC, so thank you for that. And the numbers that you just shared, just again, bring it front and center, that there's no issue more important to us in policymaker roles than to address this horrible atrocity that's attacking all of our children.
Absolutely.
Thank you, sir.
Thank you.
Thank you all again for everything you do, and know that you go forward. Our prayer is that this will really be a healing process for you today to be here and testify. And we wish you all the very best in life. And God bless you both, all right?
Thank you, Mr.
Thank you.
Thank you, Senator Barker. Senator Paxton, you're recognized.
Dan, one last question.
Yes, ma'am.
Have you ever worked with someone that was glad that they signed an NDA?
No, the answer to that is absolutely not. What often happens is, and I'll use this term, this is my term, I'm sure lawyers might disagree with me. I think it's coercion to get that to be signed, because to get, let's just say, the settlement, but that pays for healing, that pays for much more, it's just not money. And often what someone might feel is, I have to do that to get this behind me, to get some kind of resolution emotionally, physically, for my family. And so it's not as easy as really having a choice. And this is coming from a mental health professional. I don't feel it's a real choice. Some people do, but I think there's a lot in there because of the dynamics of abuse, and that perpetrator and that organization is so powerful. It's making it go away. And for some people, making it go away is all they can do. That's the only power they've got. And I need to do that. And so later down the line, when they do get help, when they do get support, as we're doing today, these brave men, is I have the power and I need to get this secret out because I've got to protect other people. When I talk to kids, I call them heroes. I'd say right to I said, you are a hero, because what you're doing, number one, is that you're telling your story, but you're protecting other kids by telling your story. You are a hero. There are kids out there that won't be hurt because of you. And truly, that I believe that with all my heart.
Thank you.
Thank you, Senator Paxton. Senators, any other questions for any of our witnesses? We thank each of you for being here, Mr. Powers, Mr. Alarcon, Mr. Garrison, Ms. Green, Ms. Allmon. Thank you very much for being here. You're excused. A few witnesses we have previously called. We want to make sure that they don't miss an opportunity if they're still interested in testifying in here. The chair calls Cindy Castilla, Rob Collingsworth, Dr. Katie Frugier.
Hey, it's good to see you again.
And those are all the witnesses that have registered, expressing a desire to testify on, for, or against. I'll ask, while public testimony is open, is there anyone else wishing to testify on, for, or against Senate Bill 835? Seeing none, public testimony is closed. Is there anyone else wishing to testify on, for, or against House Bill 748? Seeing none, public testimony is closed. Senator Birdwell, you are recognized to visit with the author about the bill.
Yes, sir.
I should say the author and the sponsor, both.
Thank you, Mr. Chairman. I think I think I understand what's happening here in section 3, but I want to make sure I'm reading it correctly. Section 3 says, subject to subsection B of this section, the change in law made by this act applies to an agreement entered into before.
Are we in the House bill or the Senate bill? Which bill are we on?
It's actually the same in both.
Section 3 is the same in both. Very
Section
good.
3 and it.
And Senator, you know the acoustics are not great in here, so if you can speak up just a
Right.
little bit
Oh,
for
okay.
me.
I'm
it'll
sorry.
help.
I'm sorry. Yeah.
Section 3,
Yeah. Section 3 of 748, and then of 835. It's just section 2. And the reason I'm asking about it is it says, the law made by this act applies to an agreement entered into before, on, or after the effective date of this act. In SB 835, that's where that section ends in section 2 on page 2 of 835. That would strike me, Mr. Chairman, that would strike me as the on or after is fine, but the before makes that section an ex post facto law, which violates Article 1, Section 9 of the U.S. Constitution. But in 748, because it says subject to subsection B says, a person, including a party, may not enforce or attempt to enforce an agreement or a provision of an agreement described by Section 129, Civil Practice and Remedies Code, as added by this act, entered into before the effective date of this act, unless the person obtains a declaratory judgment under Chapter 37, Civil Practices and Remedies Code, that is final and not subject to appeal, and declares that the agreement is or provision is enforceable. In 748, that would appear to ameliorate A, that appears to be ex post facto. This says if you don't have your NDA concluded, the way I'm reading it, Mr. Chairman, if you don't have your NDA concluded with a declaratory final judgment, then you are subject to this bill in 748.
thank you, Senator Birdwell.
So how can you
The committee sub of 835 includes that language.
Okay, I'm not looking at the committee.
They're identical.
Sorry.
They're identical
Okay,
there.
so now they're identical, and then so my interpretation of the 748 portion that ameliorates the ex post facto
Correct.
portion. Okay. Thank you, Madam Chair.
Thank you. It's a
Mr.
great
Chairman.
question.
Thank you, Senator Paxton.
Thank you, Senator Birdwell. If there are no more questions for the author, we will leave Senate Bill 835 pending at this time. If there,
And if I could just make one
of course,
short statement. I've had a lot to say, of course, with both of these bills. But the one thing that stands out to me, after all we've heard, is there's not a single person here defending the use of an NDA in these cases. We have witnesses telling their stories about the damage of these things, the expert witnesses that have worked with these individuals. And we've heard about the damage. And the damage that a person who does sign one might not even realize is coming. They're just trying to make it stop. But there is no one here defending the use of an NDA. That voice is silent. But we hear these other voices of the overcomers, as Ashton said. So thank you. Thank you, members, for listening, for caring, for your great questions. Thank you, witnesses, for your courage. And I look forward to a Texas where, as they say, no more victims, and to perpetrators, you cannot hide here. Thank you.
Thank you, Senator Paxton. And if there are no more questions for the sponsor, then House Bill 748 will be left pending at this time. And of course, the committee continues to work on these bills and move them based on what we've heard and working with the author and the sponsor. Thank you very much. The chair lays out as House Bill 128, Representative Orr's bill, sponsored by Senator Colcord.